Yes, Mr. Curry.
Lords, I'm grateful for the opportunity to consider the procedural issue that's arisen. Having considered the matter, in my submission, your Lordships, I think, have two principal options. One is simply to dismiss the action if you're against us. The other, which I would propose, would be that your Lordships remit the matter back to the Inner House, whom we would then invite to remit to the commercial judge, so that in light of the hypothesis, of course, is that your Lordships allow the appeal on this matter, so that the pursuers can consider the basis upon which that hypothetical result arrives, and consider the possibility of, if the premise of the appeal being allowed is that the contractual machinery broke down altogether, consider the possibility of bringing a claim for payment of the additional consideration anyway. Now, I have to confess that that's not an option that we've fully thought through, and indeed I don't think we could until we saw the basis of the decision.
Well, the time-honoured phrase, I think, is to proceed as a court,
Yes.
and that would leave matters pretty wide open for discussion.
And I think that's what is likely to have happened had we never had any reclaiming motion, and also on the hypothesis that Lord Drummond-Young, all that time ago, had decided the matter against us.
Thank you.
Lords, can I then move on to the issue of retention? And I have, although they to some extent overlap and merge into each other, there are really four main points that I'd like to advance. Number one, under Scots law, retention in the absence of express stipulation can only operate where the obligations in question arise out of one mutual contract. And it's not enough that, as in this case, there are two contracts which arise out of one overall transaction. The second submission, which will be very brief, is that the acquisition agreement and the services agreement are not one contract but two, which I think is accepted, but may not be. The third submission is that in any event, having regard to the intention of the parties as deduced from the two contracts, the obligations in the services agreement relied upon by Tullis Russell are not the counterpart of its obligation to pay the additional consideration.
What about the obligations in the acquisition?
I'm just going to come to that, Lord.
Sorry, yes.
And
not the counterpart of the obligation, sorry.
Of its obligation to pay the additional consideration. And four, there are no relevant averments of a right to retain the additional consideration arising from alleged breach of the acquisition agreement. Lords, had time not become rather pressing, I had been minded to read out the page or two in the opinion of the court of the extra division relating to retention, but I think in the circumstances I would invite my Lords to read it, because in my submission it does first of all address all of the issues. It's the core volume 2 at page 33 to 37.
Page
33 to 37, my Lord. And I would respectfully, I will be submitting that my learned friend has rather skirted round some of the critical issues. And my submission also is subject to one minor qualification, is that the analysis set out in pages 33 to 37 by the extra division is correct. The qualification is on page 34, about halfway down the bottom paragraph,
Paragraph number, I'm
paragraph
not using the same.
51, my lord.
Thank you.
Court says, it's of course always an aspect of freedom of contract open to parties to agree expressly performance of obligations contained in one contract between them will be dependent on performance of obligations in another contract between them, even if the contracts are not executed at the same time or can be said to have any close interrelationship apart from the fact of being between the same parties. That is not, however, this case. Whereas here a person is not seeking to rely on express practical action or retention, then the legal basis of retention is perhaps not always entirely clear. Having referred to Lord Jauncey's discussion of the topic in Bank of East Asia, Lord President Roger, in the passage cited above in the case of Macquarie, refers to the legal basis, at least in certain cases, being an implied term. It's to be noted that it appears that English law reaches, it seems, similar results as our law does, though it does so, as we understand it, by reference, at least in part, to the doctrine of consideration and also having regard to the implied intention of the parties. Now, I'm not sure that that's correct. And I'm told, although I wasn't present at that part of the hearing, that it wasn't actually something that either party submitted. And I don't want to take up time with it, but it's just a minor qualification to my otherwise complete respectful endorsement of the reasoning of the Inner House, which I would commend to your lordships. My lords, before moving on to my submissions, just one or two matters I'd like to do with by way of introduction. In his preface, my learned friend made a number of assertions about what has been established in the uncompleted proof. And the position of the respondents is that these assertions are rejected. Now, I'll deal with this in a general way, which is that our position is that whether any of the actions complained of constituted a breach of contract, and whether any such alleged breaches of contract gave rise to any relevant loss, is a fully contested issue. So that's the position that we adopt about the proof that is going on before Lord Drummond Young at the moment.
So there are no concessions on any point?
None at all.
But it's not said they're not arguable, though, is it?
No, I'm not saying that. It was rather represented by my learned friend that we seem to have agreed certain things because we hadn't crossed, and that is absolutely and utterly rejected, because there are significant issues about the proper construction of the agreement, whether certain actions are breaches of contract, and if so, whether there is even any relevant loss pled. But these are issues that I'm not in any way seeking to vindicate, but simply to identify that I do not accept any of the assertions made by my learned friend. And there's just one point of detail which I don't think matters, but because it was mentioned by my learned friend on a good number of occasions, and that is that the Tullis Russell action was raised first. The fact of the matter is that Tullis Russell raised its action without complying with the commercial protocol during the period after Inveresk had complied with its protocol, and before the action was raised by Inveresk.
Forgive me, what is the protocol?
The protocol requires that a letter is written by a party intending to raise proceedings, outlining, it's in compliance with the practice note, outlining the basis of the action and so on and so forth, to give the other party an opportunity to respond. So I don't...
What I would call a letter before action.
Yes, but it's in
more,
terms...
But more formal than that,
yes,
is it?
Yes.
So this is a practice note in the Court of Session?
It's a commercial court practice note.
Right, I see.
And I don't think anything really turns on who raised the action first, but since it was mentioned, as I say, on at least half a dozen occasions by my learned friend, I'd just like to put that in proper context. Now, Lords, can I then deal as quickly as I can with the proposition that In the absence of express stipulation, retention can only operate where the obligations in question arise out of one mutual contract.
And so you don't accept what Lord Glennie says about this? Do you?
No. And yes, so there's another technical point, I think, raised by my learned friend. Before the Inner House, I think, as I understand it, although I wasn't present, the debate was dealt with by my learned friend, Mr. Lake. The Tullis Russell's counsel suggested to the court that the matter wasn't before them because there hadn't been a formal cross-reclaiming motion, but the court took the view that the matter was before it. So our position has been, since Lord Glennie so opined, that the obligations did require to arise out of one mutual contract. Rod, can I treat as my starting point tab 48, which is Globe? Sorry, it's tab 48 in volume 2 of the Authorities. And it's page 624, which is the third last sheet in the tab. And Gloag says right at the foot of the page, on the same principle, a debt which is admittedly due and payable cannot be withheld on the plea of retention in respect of a claim of damages which does not arise directly out of the same contract. And he cites, in support of that proposition, passages from Erskine, Bell, and Lord Cranworth in National Exchange Company against Drew in 1855. And National Exchange, which I don't think it's necessary to go to, is
39.
tab 47. I'm sorry, Erskine is tab 47.
39.
And yes, National Exchange is tab 39. And subsequent to National Exchange against Drew, I'd like to look briefly at tab 29 in volume 2, which is a case of Johnson against Robertson, which is mentioned in quite a lot of the case law, including very recently. And I'll try and save time by not reading the head note. I'm going straight to the opinion of Lord Benham at page 652, about halfway down the page, where Lord Benham says, the plea of the defender is based mainly on the rule of the law of Scotland that one party to a mutual contract in which there are mutual stipulations cannot insist on having his claim under the contract satisfied unless he is prepared to satisfy the corresponding and contemporaneous claims of the other party to the contract. I think the rule of law that an illiquid claim cannot be set off against a liquid claim does not apply to such a case, and that at all events, if the one claim be liquid and the other part be illiquid, yet contemporaneous, the rule should suffer some qualification or relaxation if the claims arose under one contract. And to the same effect, Lord Cowan, at page 654, about halfway, if one goes to the middle, he says there is a passage in Stair, and about halfway down that paragraph he says, but this passage may be held to apply to the case of liquid debts unconnected with each other, which is not the kind of case which we now have to deal. I cannot doubt that opposing claims arising out of one mutual contract may be dealt with in this way, and so on. And then the Lord Justice Clerk at page 656, not quite so clear, the second complete paragraph, the defence arises out of an obligation in a mutual contract, which is to be enforced at the same time as the stipulations in favour of the pursuer. So that's Johnson against Robertson. And the next case, I could perhaps just note in passing that in tab 10, the British Motor Company Limited case, in 1914, Lord President Strathclyde at pages 926, third of the way down to 927, refers to and implicitly approves Johnson against Robertson. In tab 46,
But do any of these cases focus on the point we're on, which is whether it's sufficient for the relative obligations to arise out of the same transaction, though not the same contract? Of course, if you're only looking at a case about one contract, one would expect the principle to be stated in the context of the same contract. But so what we need to be looking for is to see whether there's anybody applying their mind to the question, whether it applies only in the case of a single contract, or whether it may also apply to the case of the same transaction, where the other ingredients of the rule apply.
I understand that, my lord. Without accepting that where they say one contract, they don't mean one contract. But if I could just give, I'll come on to a case where I think it was in it, a couple of cases where it was an issue.
Are you coming on to the next paragraph of Globe? Because that deals with the other end of the spectrum, which is unconnected contracts.
Yes. Yes, I was going to come to this and say that does my lord have in mind page 595?
No, 625, first complete paragraph.
The rule is the same when the illiquid claim is founded on a claim under a contract or for breach of contract, so long as the contract is not the one out of which the debt that is sued for arises.
Yes, and then it deals with a number of cases of continuous contracts, but not arising out of the same transaction.
That's to do with the course of dealings. If I could just, since we're on Globe, if I could just mention what is said at page 595 under the heading Presumption for Interdependence.
595.
595 of Globe.
Yes.
He says, this was read by my learned friend yesterday, it's clear that two contracts having no connection with each other, except that they are between the same parties and entered into at the same time, may be constituted recorded in one document. In such case, there's no ground for holding the right to exact performance of one contract as in any way or in any circumstances conditional on performance of the other. So he's saying it's not a sufficient condition that the obligations are contained in one contract. But he then goes on to say, but there is a general presumption that the reason why the parties have not recorded their agreements in separate documents is that they intended them to be dependent on each other. And I would suggest that the corollary of that is that if parties have recorded their agreements in separate documents, there is a presumption that they did not intend them to be dependent on.
But perhaps these presumptions are rebuttable.
Yes, oh yes, I accept that, and that's why I qualified my proposition by saying in the absence of express stipulation.
But we do know why they were in different.
Sorry, my lord?
We do know why they were in different documents.
Well, perhaps I could deal with that. We have been told, and we don't dispute, that the reason there was a services agreement was that Inveresk wanted an income stream to set off against its tax losses. And that accounts for, perhaps is one of the reasons why there is an agreement to pay a monthly service fee of £1 million over the 5 months. What it doesn't explain is why some of the other obligations were included in the services agreement, in particular in paragraphs, in clauses 15 and 16. So I don't accept that the fact that there was a tax motivation for having a services agreement undermines the presumption that in relation to some of the obligations, parties included them in the services agreement, or are to be taken as including them in the service agreement because they did not intend them to be interdependent with obligations in the acquisition agreement. And if I could, one of the reasons I wanted to read the opinion of the court at page 33 to 37 of the extra division in full is that quite some degree of emphasis is placed by the court on this passage from Globe. Now, Lords, if I could just notice, without going there, that in Turnbull against Maclean, which is tab 46, Lord Benham at page 739. In this,
Beg your pardon, which
sorry, Lord, it's Turnbull against Maclean,
Yes.
Tab 46.
tab 46.
Did you say Lord Benham?
Yeah, if I could just, yes, tab 46, page 739. Again, I accept this is not a case in which this issue was before the court. Lord Benham says, it is very important that we should express our determination to abide by the well-established rule of Scotch law that in mutual contracts there is no ground for separating the parts of the contract into independent obligements so that one party can refuse to perform his part of the contract and yet insist upon the other performing his part. The unity of the contract must be respected. And in my submission, that is consistent with the view that the principle is rooted in the proposition that in one mutual contract, the obligations are thought to be interdependent in the absence of some stipulation to the contrary. And Lord Neves, I'm of the same opinion. It's a general principle that all the material stipulations in a contract forming an unum quid are mutual causes. So I would take that as being to the same effect.
So how does that assist you?
It's consistent, my Lord, in my submission with the view that for obligations to be interdependent or counterparts, they must arise from the same mutual contract.
So he's saying that if they are in the same contract, then they are presumed to be interdependent.
Yes. But
Doesn't
well, no,
doesn't
Lord,
prove
no,
that if they're
no,
not in the same contract, that they're not.
Lord, I take my Lord's point that they're not, so far we've not been dealing with cases where there is more than one contract. All I'm really seeking to establish is that the origin of the rule is related to obligations in one mutual contract. I think the matter is...
So can I just, I mean, I'm sorry to, it's not directly, but supposing that I buy a vase from you and I pay £60 for it, and it's agreed that I'll pay it in 2 months' time, but in the meantime it comes to my house and so on, but I think there's something not quite right about it, and I ask you to come round. Or you're not, let's say I don't even ask you to come round. You come round to my house and you are looking at my vase, yes? And you drop it and damage it.
Yes.
Can you sue me for the price? And can I?
No. Yes, I can.
And
Yes.
I can do nothing.
No. You can sue me back.
That's
You
all.
can't retain the price of the vase.
So that it goes as far as that.
Well, I think perhaps I should have not tried to cut corners. If we go
No,
back,
it would be helpful if you didn't.
if we go back to National Exchange, which is tab 39, and page 120 in the, it is termed the opinion of the Lord Chancellor's opinion. I think the passage that's cited in Globe is at page 122, but I think in order to understand it, you have to go back a bit. And Lord Cranworth says at the foot of page 120, I agree that in order to vitiate a contract and to make it a nullity by reason of fraud, it must be a fraud according to the language which has been so often quoted, dons locum contractui. That is, if the pursuers were right in saying that the loan was one independent transaction, and the purchase another independent transaction, the circumstances of the defenders have been induced by the fraud of the lenders to make the alleged fraudulent purpose would not vitiate the transaction of the loan. I accede to that argument. I think if I fraudulently represent to another that something in the market is worth £100 when I know it's not worth 100 pence, and he says, upon the faith of your representation, I will make the purchase, but I have not the money, and if I say, very well, I will lend you the money, I do not think that upon that loan of money, when the time came at which I was entitled, according to the contract respecting the loan, to sue for the money, the party who'd borrowed could say, as a defence to my action, I should not have borrowed this money of you if you had not told me that the mode in which I was going to apply the money was a lucrative instead of being a disastrous purchase.
Gosh, that's rather surprising.
I think that's analogous, my lord, with the situation that your lordship postulated, which is I would suggest, a counterpart for the transfer of the property of the vase is the price, and it was a different, whether it's a contract, I suppose it is a contract, well, perhaps it's not a contract.
I just assumed to help.
But it would be a delictual claim.
Yes, I'm assuming it is.
And in my submission, because they don't arise out of the same contract, it's not a delict in performance of the contract. I think that's what Lord Cranworth is getting here. You would not be entitled to retain the price because I had knocked the vase over and smashed it into 1,000 pieces.
But wasn't there a fraudulent inducement to accept the loan as well, in this case?
Yes. I think that's right. I think he's going that far. But under Scots law, fraudulent inducement to advance the loan would not entitle you to retain repayment of the loan.
If you come round to my house and knock it over, no, can't. But if I ask you to come because I think there's something wrong with the vase, which you've supplied me with, then, and you knock it over, then in that case I can set it off.
If the contract was much more elaborate than such a transaction would normally envisage, and the contract included a provision that I had to come round and clean the vase,
Yes, yeah.
then at least you're relying on a term within the contract. There might be another issue, a subsequent issue as to whether there were counterparts, but you wouldn't be blocked by what I submit as the rule that they must arise out of the same
It's
contract.
rather the counterpart bit I was really thinking
Yes.
about, Mr. Curry.
Yes.
I was wondering how far this counterpart thing
Well,
works in this
I'm
particular area.
I'm certainly going to come to look at that, but really what I'm trying to convey at the moment is that if parties elect to use two contracts, I submit the presumption is that they did not wish the obligations in one to be the counterpart of the other. That can be affected, as the inner house decided, by express stipulation. But there is also even if the obligations are within the same contract, one would have to consider whether they were counterparts, although the Scots law seems to suggest that there is a presumption that if they're in the same contract, they are the counterpart of each other. Rod, I think the issue was perhaps live in the case of Fulton Clyde, which is tab 19, in volume 1 of the authorities. Fulton Clyde, which is tab 19, I think.
So these are two different contracts, are they?
Yes.
Can you give me your reference again?
Sorry, my lord?
Can you give me the reference again?
Yes, it's tab 19 in volume 1 of the authorities.
Sure.
And perhaps worth reading the head note in this case. It's a judgment of Lord Migdale sitting in the outer house, and the head note is in an action to recover the balance of the price due for steel sheets duly delivered. The defenders admitted that the sum claimed was due, but averred that payment was withheld in respect of their claim for damages arising out of the non-delivery by the pursuers to them of 50 tons of reinforcing rod in coil ordered from the pursuers, they averred that the order for rods was an item in the general course of dealing between the parties, held that to justify retention, liquid and illiquid claims must both arise directly out of the same contract, and the defendants are not entitled to retain the sum sued for, an interim decrease for that sum pronounced. And I think at page 254, column...
These contracts are made quite a long way apart, aren't they? The facts are stated at the bottom of page 253.
Yes.
Yes, and the attempt to set up retention was predicated on the proposition that the orders were in the same general course of dealing between the parties.
Yes, it's the 254 right-hand column
Yes.
at the bottom. And this is really the same point that Clove makes at 625.
It says, I'm not prepared to accept this view. I do not think it's enough to justify retention. The defenders placed a succession of orders with the pursuers. If each order is part of a wider contract, that might suffice. So what he's saying there is if you've got one contract which makes provision for a series of orders, that might suffice.
Yes.
But that is not the case here. To justify retention, I think the liquid and illiquid claims must both arise directly out of the same contract. A course of dealing is not the same thing as a general account, and so on. So that's the way Lord Migdale understood Gloag and applied it in that case.
But do any of the cases deal with a one transaction situation?
I don't...
Otherwise he'd be leaving his knowledge.
I think perhaps the nearest one gets to that is, at least there was an argument to that effect in tab 12, the Claddah Steamship Company, which is volume 1, tab 12.
What I don't understand is what is the rationale for having a rule which draws the line between the one contract case and the one transaction case, provided that the other ingredients of the principle are established. I mean, if there is mutuality and there is an appropriate counterpart, if that's the right expression. So if those parts of the test are satisfied, why does it make any difference whether they're in one contract or in two contracts, part of the same transaction? Just a matter of principle.
I think in distinction from English law, Scots law doesn't apply a broad equitable approach. It applies rules, and one of the rules is that, according to Gloag at page 595, there is a presumption that if parties, perhaps I should, rather than trying to remember it, I should...
it's the doctrine of unity.
It was really tab 48 at page 595. He says, as a general presumption, the reason why parties have not recorded their agreements in separate documents is that they intended them to be dependent on each other. So my submission is that one of the tools that Scots law uses for dealing with the matter is to, as a corollary of this, is to presume that if parties have chosen to set out their obligations in two separate...
Well, I can see that might be the starting point, and that might be a reason for having a presumption.
Yes.
But so long as it's not an irrebuttable presumption, then it can be rebutted. So at the end of the day, it all depends upon the circumstances.
Yes,
so if these other criteria are satisfied in the transaction case, it's no answer to say, oh, well, there were two contracts.
my Lord, my submission is going to be that even if you reject my submission on this point, if you look at... And as I said earlier, my submission is qualified by the recognition that if there is express stipulation to the contrary, then an obligation in one contract may be regarded as the counterpart of an obligation in another.
Well, obviously that's one example, but that's not the cases don't say that's the only example of a circumstances where the presumption can be rebutted, do they?
I mean, it may not be a very good answer, my Lord, but it does seem to me that for two 200 years or more in Scotland, the law has been that for retention to apply, the obligations must arise out of one mutual contract.
Well, I'm not sure that, I mean, that's, I'm not convinced that they've laid that down as a firm rule. You know, that it's in the context in which those remarks have been made makes it clear that that's what they were talking about.
Let me call it a presumption then rather than a rule.
But I'm looking at passages from Macquarie against Celtic Football Club, which are quoted in the appellant's case at page 24, and I'm using this to save looking up the bundle. But the Lord President there was drawing a contrast between simple cases and the more complex one arising out of complex contracts containing a wide spread of obligations. And the thrust of the discussion there is concentrating on the obligations as to whether they're counterparts of each other. And if you concentrate on the obligations and whether there is a counterpart in one contractual arrangement as compared with another, the places in which they're found are not so critical. It's just so long as you can see that one is undertaken as a counterpart of the other.
But, my Lord, my submission is that it's a strong indicator of whether parties intended the obligations to be interdependent,
well,
whether they included them in one contract or more than one.
Well, as is said in Macquarie, one has to have regard to the circumstances.
Yes.
So, I mean, that's really about as far as this point would take you, I would have thought. So we now look at what these contracts contain, do we, to see whether there is anything to support your position that they must be taken to be separate.
Well, Lords, I'm just about to come on to do that, but in the respondent's submission, the passage in Glogue at the foot of page 624 is an accurate reflection of the law of Scotland, read with, no doubt, what is said at page 595. And perhaps before we go there, if I could just notice in tab 23 in volume 1 of the authorities what Lord Drummond Young said in paragraph 9. Where he distinguishes between systems such as Scots law, where the concept of the equitable interest is unknown, and quasi-proprietary rights cannot arise merely by virtue of a contract. So my submission is that what the position may be in England is not a helpful key to understanding the law in Scotland, because the systems are really quite different.
Well, I think that leads on to the passage just below letter E, where he's saying, well, since you don't have the advantage of the equitable approach, then you have to take a view of the principle which doesn't apply it in such a way as to substantially curtail the availability of the defence of retention, which is a warning that one perhaps ought to be careful of not being too black-letter law about this.
Indeed. However, my Lord, my position remains as set out in Glogue, as I've said. Now, can we turn then to look at the contracts? And I think the first point I'd like to make is that if one looks at page 262 in the appendix, we can see from the recital, and I mean, this is self-evident, that this is a nominate contract under Scots law for the sale of assets. And if one looks at the recital for the services agreement at page 302, we can see that this is quite clearly a contract for services.
I'm not sure how far that point which Lord Clark places a lot of weight on takes you, because they could have been included in a single contract, couldn't they? One single document. One could have had all these various provisions included.
Yes. And that, in my submission, that cuts both ways, because if I'm right that the decision by the parties to include the obligations in two separate contracts raises a presumption, then the presumption is that because we have two separate contracts, then in the absence of express stipulation or anything else to indicate to the contrary, the obligations in the services agreement were not intended by the parties to be the counterparts of the obligations in the asset acquisition agreement. And if we move on and look at clause 7.1 of the acquisition agreement, which is at page 270, it's quite clear, and again, in a sense I'm stating the obvious, but it's perhaps necessary to make this point in view of the fact that my learned friend sought to use language like the acquisition document and the services document, that even within these two agreements, it's recognised that there are two agreements. It's acknowledged and agreed by the vendor and the purchaser that the sale of the assets anticipated in this agreement and the provision of services anticipated in the services agreement, dated of even date, and so on. So that one doesn't take from the terms of these agreements that they are one agreement.
Does that 7.1 work, Mr. Kelly?
I'm sorry, my lord?
Does it work, 7.1?
Shouldn't think so.
Doesn't look like it. It looks like a very optimistic thing, but yeah.
I don't know if it does. I'm not very much about employment law, but
I shouldn't think it does for a minute.
yes. But really, the point simply is that
I know.
if it, yes, and again, it's a kind of self-evident point.
But it really had to be put that way in view of the fact that it had been decided to have two separate agreements.
Well, indeed,
I
but
mean, that's just...
at certain points, my learned friend seemed
And
to...
it was put that way because it was thought that they might be closely related. Because otherwise, you wouldn't have it in the transfer of assets agreement, would you?
My lord, I don't dispute that these agreements are closely related. Right. My submission is that that's not enough.
Right.
Now, if we go to page 278, we have the entire agreement clause, and there's the equivalent in the services agreement at page 315. And it says, this agreement together with the I'm reading from page 278, this agreement together with the documents referred to in it or executed at completion constitutes the entire agreement and understanding between the parties with respect to its subject matter and replaces and supersedes all prior oral and written agreements, understandings, representations and correspondence regarding such subject matter.
But one of them is the services agreement, isn't it?
Yes,
Together with the documents.
Yes.
So read literally, it's one contract.
Well, that in my submission is not the right way to construe these clauses. And my submission is that the purpose of the entire agreement clause is to restrict the terms of each agreement to the agreement itself, and in respect of other documents mentioned, to those parts of those agreements referred to. So there is, in other words, what I'm saying is that there is not a wholesale incorporation of the services agreement into the asset purchase agreement and vice versa. It's simply a reference to the other, insofar as there are references within.
Well, it's just a boilerplate provision
Yes.
coming originally from American practice. designed to ensure that the parties can't rely on alleged oral agreements or representations. It doesn't address the point we have here at all.
And you get a matching provision in the other contract for the same reason.
Yes.
But, the subject matter, so far as it goes, is different in each case,
Yes.
as I think you pointed out once talking in this agreement about the provisions which deal with the transfer of the assets.
Yes.
But this agreement deals with trademarks and customer information, and the provisions of clause 16 of the other agreement deal to some extent with the protection of those rights which have been transferred under the assets agreement.
Lord, I'll turn to look at some of these provisions now then. So far as the services agreement, the clauses that the pursuer's alleged breach of are 2.1c and E, 5, 14.6, 16.2d. And if I could just look at those, if we start off with, and we're in the services agreement, if we start off at page 305 to clause 2, it's provided that the parties recognise that the purpose of this agreement is to allow Tullis Russell time to integrate the manufacture and distribution of the products into its existing operations without adversely impacting on the manufacture and supply of the products in the period prior to the completion date, and to protect the value of Tullis Russell's investment in the owned intellectual property rights in terms of the asset purchase agreement. In consideration of the fee identified in clause 3 below, and at the request of Tullis Russell, Inveresk shall, during the life of this agreement, and various obligations are set out. And so these, what the parties have expressly stipulated in my submission is that they have identified the counterpart of the fee identified in clause 3 as the obligations set out in 2.1a through to J. And so on. And then when we get to clause 3, in consideration of Inveresk continuing to manufacture and distribute the licensed product, the undertakings provided by Inveresk to Tullis Russell in respect of the maintenance of the trademarks during the life of this agreement, and the use of the trademarks in accordance with the terms of this agreement, but subject to clause 3.4, Tullis Russell shall pay to Inveresk a monthly fee of £1 million sterling payable on the following dates. So we see from clauses 2 and 3 what the counterparts are of the obligations set out there.
Does that exclude any other counterpart then?
Well, it doesn't say including the sale of the assets. So it does, yes, my lord, by implication.
This is a commercial action. In one of these documents, the purchaser says to the vendor, I am buying your trademarks, your customer information, and I'm going to pay you additional consideration based on sales of products containing what were your trademarks. The vendor says, I'm going to use all reasonable endeavours to protect those trademarks in the other agreement. Now, no commercial person would say, maybe the law is different, but would any commercial person say, if you don't protect the trademarks, I'm not going to pay you the additional consideration?
Well, he might well say that, but...
And that's not the law.
It's not the law.
It'll be an English heresy.
Just on that, my lord, if we go back to the acquisition agreement, at page 268. Clause 2, sale and purchase of the assets. The vendor agrees to sell as beneficial owner, and the purchaser agrees to purchase the owned intellectual property rights, the customer information, and the related assets free of all encumbrances, as at the close of business on the completion date for the consideration. So it's made quite clear what is given in exchange for the consideration, which includes the additional consideration. It is the sale of the assets stipulated in clause 2.
If nothing was said, and suppose nothing was said, and they had done something which was either deliberately or carelessly had damaged the goodwill. It was just they bought the assets and then so they sold the assets, and then they had, before the price was due, they had damaged the goodwill carelessly or whatever it was. You might say you might argue there was an implied condition that they should not do so. In that situation, you would say it might be entitled to retain. Would that be right? But if you're paid for it, and it happens to be another contract, you say no.
Well, if you weren't able to hand over that which you'd agreed to sell, then I would accept that you might be able to retain the consideration, but that would be the analysis in my submission.
Because it had been damaged.
Because
as I understand it, that's what they're saying.
Because you weren't able to satisfy clause 3.1, because it'd be implicit in that you were not handing over something that wasn't what was contracted for. Lord, can I, just on this, can I remind my Lords of what is said in the South African case, UKSC Financial Services, which is in Volume 1 at tab 18. And again, it is, I think, worth understanding a little about the facts. I'll just read the head note. About halfway down, in terms of an agreement, the plaintiff was to receive payment of an amount on the capital appreciation of the portfolio of shares administered by it. This payment was in no way dependent upon the performance by it of any duties imposed by the agreement. In an action for payment of this amount, the defendant pleaded inter alia that the plaintiff had failed to exercise skill and judgment in the management of the portfolio, and therefore had failed to perform its obligations under the agreement. In an exception that such a plea did not disclose a defence, held the defence did not measure up to the requirements of the exceptio non ad impleti contractus and could not be justified. And at page 809, Mr. Justice Corbett, about just below letter D, said for reciprocity to exist, there must be such a relationship between the obligation to be performed by the one party and that due by the other party as to indicate that one was undertaken in exchange for the performance of the other, and in cases where the obligations are not consecutive, vice versa. And at the foot of the page, just below letter H, or just above letter H, in applying these principles to the present case, the first question which arises is whether the basic requirement of the exceptio, viz. Reciprocity of obligation, is satisfied, and contending that it is not, Mr. Comrie submitted that in terms of clause 6 of the instructions, plaintiff's right to receive payment of an amount equivalent to 1/6 of the capital appreciation of the portfolio in excess of 10%, and the defendant's corresponding obligation to make such payment were not in any way dependent upon the performance by the plaintiff of his duties of portfolio management. Indeed, they were dependent merely upon a certain result, namely a capital appreciation in excess of 10% being attained. Because of the manifold factors which influence the rise and fall of prices on the stock exchange, this result might come about irrespective of whether plaintiff performed his duties efficiently or indeed at all, and conversely, the performance of these duties in the most efficient manner possible might fail utterly to produce the result. And the judge goes on, it seems to me that Mr. Comrie is correct in contending that the necessary reciprocity of obligation is not present in the instant case. It's true that in terms of the contract between the parties as set forth in the written instructions, it was intended that as long as plaintiff's authority remained unrevoked, it should have carte blanche in the management of defendant's investment portfolio. It was given unfettered powers to buy, sell, or exchange securities, and defendant was debarred from in any way interfering with or instructing plaintiff in the carrying out of its decisions. It was plaintiff's function to provide analysis, research, and judgment in the selection of the securities for investment and to take the appropriate decisions on defendant's behalf. It's common cause for the purpose of these proceedings, at any rate, that plaintiff is obliged to exercise skill and judgment in the performance of its contractual obligations. As consideration, therefore, plaintiff is to be paid in advance a management fee of 240 Rand, and in addition, it was to receive the benefit provided for in Clause 6. This clause makes it clear that the objective of this management scheme is to obtain capital appreciation on the investment portfolio at the rate of 10% per annum. It is significant, however, that it is expressly stated in Clause 6 that plaintiff's right to receive what is in effect a bonus represented by 1/6 of any share of any capital appreciation in excess of the 10% aimed at is in consideration of the planned objective being achieved, not upon the satisfactory performance by plaintiff of its duty of management. And at the foot of the page, had the parties intended the payment of the bonus to depend as a precondition, not only upon the achievement of the required capital appreciation, but also upon the satisfactory performance by plaintiff of its duty of management, then one would expect the contract to have reflected this in clear terms.
Well,
so,
what are we to take from that passage? Because it seems to turn very much on the terms of the particular contract, doesn't it?
yes. Well, the first thing I'd take is that the court has regard to what the contract states is in consideration for what in deciding whether an obligation is given in exchange for another.
Is there a separate doctrine of exceptio non and inflated contractus in Scots law?
I don't think that's the way we state it, but I do understand that the Lord President of Macquarie, Lord Roger, I think treated
It's much the same kind of doctrine.
yes, this case as of assistance in understanding the
What was? I mean, what was it? She was claiming he was claiming what for a bonus of some sort. Is that right?
My Lord, what it was that he was entitled to a commission if the portfolio achieved a certain level.
And that's independent, it was said, of whether he performed his duties properly or not. So he got his bonus just simply because...
I'm not at all quarrelling with the result. The point I'd like to make is that one might have thought that a bonus derived from performance of the portfolio was connected to the obligation to look after the portfolio. If the broad approach which the appellants in this case would commend to the court is accepted, there is that connection. But the court is in ESC is looking quite carefully at the terms of the contract to see what is given in consideration for what. And in our case, it's quite clear from the acquisition agreement what the consideration is given for. And in the services agreement, as we go through it, I haven't quite finished, we'll see that the parties have stipulated what obligation is given in consideration for what in that agreement.
I may have touched on this yesterday, but in English law, even where the requirements of equitable set-off don't apply for some reason or other, the court still can stay execution of the judgment in order to ensure that injustice isn't done. Now, is there anything in Scott? There's not.
I don't believe so.
We did. Yes. And what the reason for that is a judgment is a judgment. There's no power to stay execution.
Certain circumstances you can suspend extract, can't you?
I don't think there's any equitable solution. Really.
Presumably get a freezing.
I think it's just the obligation is enforceable, really,
Yes.
isn't it? I mean, as I mentioned before, this comes up in specific performance or specific implement, where the court doesn't have a discretion. If you're entitled to implement, you can get it without further discussion.
Where the judge here says at the bottom of page 810, had the parties intended the payment of the bonus to depend as a precondition, not only upon the achievement of the required capital appreciation, but also upon the satisfactory performance. Does the doctrine really require that one establishes that the parties intended that one should be the precondition of the other? Is that the test?
Well,
that's too strong a test.
I think that's just one way of putting it, and I think it is.
Yeah, but that's quite a strong way of putting it.
It is quite.
I mean,
close
simply surely we're looking at some sort of obligation, a mutuality of obligation in a broader way than that.
I think, it's quite close to the way Gloag puts it at page 623 in tab 48. Under at the bottom of the page, under the heading Forms of a Right of Retention, the right of one party to withhold performance of the obligations he has undertaken on the contract until performance of the obligations in which he is creditor is given is usually termed a right of retention. The word is perhaps used widely enough to cover all cases where A refuses to perform his contractual obligations to B on the ground that these obligations are impliedly conditional on the performance of counter obligations due by B. Which I think is quite close.
The difficulty, I mean, I've been wondering about this all with it. I mean, the use is Gloag saying there's a narrower version of retention as well. I mean, when he says the right
I don't
is
think so.
usually termed a right of retention.
I read that as really being
That's it. I mean, sometimes, as I read it, I think in one of the passages quoted by Lord Johnson, they talk about, of course, the kind of retention we're thinking about here as being, in effect, a sort of form of security,
Yes.
which you have for for the payment of the
yes.
damages which you might be entitled to under the other thing.
I think the honest answer is I don't know, but I think what he may be suggesting is that retention may be applied not only to cases where you're trying to exercise some form of security, but where, for example, the other party is trying to get you to perform
Yes.
a contractual.
And you say, no, I'm not doing that because you haven't done what you ought to have done.
I think
Yes.
that's what he's getting.
I think that's what he is getting
Yes.
at there.
But
I mean,
Our case is different, isn't it?
Yeah.
I mean, is our case not the one at the bottom of page 626 and the top of page 627 in Gloag, which we looked at yesterday? His remedy is then to withhold performance of his obligation to pay in security of his claim for
Yes.
damages for the defective character of the work.
Yes.
His obligation to pay is not extinguished,
yes.
but postponed, though it may ultimately be distinguished
that
from the
would
principle of
apply.
compensation.
Yes.
I think that
Surely
would
that is what the doctrine of retention in this class of case is designed to deal with.
And
But
So you have to be careful about some of these broader statements,
Yes.
such as that of Mr. Justice.
I mean, the ESE case isn't that kind, is it? I mean, the problem in ESE was really is to try to understand what the entitlement under the contract was for. And as you can see from the top of page 810, the phenomenon of the market rising and falling, independent of the efforts of the individual financier, banker, whatever he is at the back of this. You got your bonus because the market went up by the required amount. That's how they construed the contract. And therefore, the argument that he was in some way inefficient or whatever else was of no greater importance than the fact that he'd been super efficient. If he'd been very efficient and the market hadn't achieved its figure, then he wouldn't have got the bonus.
Yes, but I would say that the broad approach, which was rejected in ESE, is inherent in the approach taken by the appellants in this case, which is the consideration that the parties state for the transfer of the assets is the additional consideration, or the additional consideration is for transfer of the assets. But because you didn't perform the services agreement and that had an effect on the assets, you're not entitled to the additional consideration. It's an equally indirect link, I would suggest, to the one which was sought to be set up in ESE. I think that's really what I would invite my lords to take from that it's a rejection of the indirect approach taken by the appellants in this case.
I mean, supposing we go back to my vase and let's say it's worth £20,000 or something like that, and there's an agreement with you, you sell it to me, and you will also come and polish it until the day when I actually have to pay for it.
Yes.
And you come, and I say I'll pay you £100 a visit to polish it, and during one of those visits you damage it. Would the fact that I'd stipulate a separate consideration of £100 a visit make any difference?
Yes, I would say that the consideration for the vase was the price, and if I damage it, then your remedy is to sue me for the cost of repair.
Yes, and I can't withhold it. I can't withhold anything against that in the action when you sue me for the price.
Well, we get over the one contract problem because the parties are presumed to have.
But there's an obligation of there's a special consideration of £100 a visit for your polishing. Would that make any difference?
Yes.
Would.
Indeed, on the authority of ESE, if that's correct, then what one does is one looks at what the consideration is, and you've got two quite different obligations. One is for the sale of an asset for which a consideration is specified, and the other is for performance of a service for which the consideration is specified. So in my submission, the two are not the counterpart of each other.
And therefore you can't retain.
Yes. But the position is stronger in this case because, as I would have it, the parties are to be taken to intend that the obligations of one agreement are not the counterpart for the other because they've set them out in separate contracts, and the tax explanation doesn't work in my submission for when we look at 16 and 17.
So the purpose of setting out the only purpose other than tax for setting them out separately is for this purpose, to avoid the doctrine of retention.
Yes. That is the presumed intention of the parties, and the appellants could easily have got round that by insisting on a stipulation that all the obligations in the services agreement be the counterpart of all the obligations in the acquisition agreement, or vice versa, or done it on an individual basis. But if we carry on and look at other provisions in the services agreement, could I just before we go there, could I just mention that ESE, I think as my lords know, was commented on in Macari in Volume 2, Tab 33 of the authorities. At the foot of page 640, the Lord President says this: Lord Jauncey does not spell out circumstances in which one obligation will fall to be regarded as the counterpart of another. Sometimes, of course, the express terms of the contract will regulate the matter. In other cases, it depends on the intention of the parties as gleamed from the terms of the contract. Lord Maclaren said as much long ago in Civ Right against Lightbourne. The question whether the obligations are conditional with respect to one another so that non-performance by the one party entitles the other party to withhold performance of obligation is always a question of intention, to be determined by the terms of the contract itself and the surrounding circumstances, which often point to implied terms. A somewhat similar approach was laid down by Justice Corbett, as he then was, in ESE, and there's a quotation of the part of the passage that I read out, and Lord Roger goes on, in the present case, I've approached the matter on the basis of the Bank of East Asia. So if we're directed to look at the terms of the contract, my submission is that the services agreement, first of all, that the acquisition agreement makes it clear what the consideration is in consideration for, and the services agreement makes it clear what the obligations in that agreement are in exchange for. And I've looked at, clauses 2 and 3. If we look at clause 15,
in the acquisition agreement.
in the services agreement, well, it's page 312.
Yes.
Inveresk undertakings in relation to the quota. To enable Inveresk to perform its obligations in clause 2.1 above, Tullis Russell acknowledged that Inveresk will be required to, and Inveresk undertakes to repair and maintain the quota on a fully commissioned basis until the completion date, 15.2, except with the prior written consent of Tullis Russell in consideration for the payment of £1, receipt of which is hereby acknowledged, Inveresk shall not, whether on its own behalf, and so on, dispose of the quota so as to allow the quota to be used at the Cairn Grove property in any manner by any person carrying on or commencing business in competition with the restricted business. So, again, there's an express stipulation as to what is in consideration for what.
But doesn't one have to read that along with the preamble at page 302, capital letter C, where one sees what the purpose of this all was, to enable Tullis Russell to obtain the full benefit and value of the assets being acquired under the asset purchase agreement.
Well, Lord, this is going back to a much broader test than Scots law applies, which is to look at whether obligations are in some way connected. In my submission, under Scots law, one has to look at what an obligation is given in exchange for, and the intention of the parties as set out by them expressly in the contract is an indication of what that is.
Well, this is an expression of intention, isn't it, in C? It's explaining why these undertakings are entered into.
In very general terms, but what the parties are doing in the individual clauses is identifying what is given in exchange for what.
Well, they can't, I mean, commercially speaking, they can't have thought £1 was a suitable consideration, can they? I mean...
Well, I hadn't quite finished reading
I beg your pardon.
15. In consideration of the undertakings given by Inveresk in clauses 15.1, accrued and subject to compliance by Inveresk with such undertaking, Tullis shall pay the accrued quota fees to Inveresk on the completion date, and so on. So we have clause 15 in my submission, has its own scheme of reciprocal obligations. And again, if we look at clause 16, in consideration for the payment of £1 by Tullis Russell to Inveresk on the effective date, receipt of which is hereby acknowledged by Inveresk, Inveresk undertakes to Tullis Russell, in the manner set out in clause 16, to enable Tullis Russell to obtain the full benefit and value of the owned intellectual property rights, customer information, and related assets. So that's a very specific statement there. And then we have the various undertakings. But the matter in relation to 16 doesn't finish there, because in clause 17, which is headed severability, they say the parties confirm and agree that they consider that each undertaking in clause 15.2, and I think it's obvious that that should be 16.2, D has been taken into account in determining and is adequately compensated for by the amount of a consideration paid by Tullis Russell for the undertakings provided by Inveresk pursuant to the terms of this agreement. So again, we have another part of the scheme which makes it clear in my submission that the obligation, not the general purpose of the agreement, but the obligations, the individual obligations, what they are given in exchange for. Lord, yes, and I think any suggestion that the true consideration for the assets is the sum of the monies payable under the acquisition agreement and the monies payable under the services agreement is refuted by the fact that the services agreement may be terminated by Tullis Russell, which would have the result that Tullis Russell had acquired the assets for less than the cumulative consideration for the two clauses, and it's clause 10. Yes, and the relevant clause at the top of page 310, 10.2, if either party shall be in material breach of any of the terms of this agreement and fails to remedy such breach to the satisfaction of the other party, within 30 days notice of such breach, a breach notice given by the second party, then the second party may terminate this agreement with immediate effect by notice the first party given at any time within 30 days from the expiry, and so on. And one of the events upon which termination, one of the other events upon which termination may be effected is 10.1a if Inveresk goes into liquidation. So what is quite clear is that Tullis Russell may acquire the assets for the consideration in the acquisition agreement, full stop. So in my submission, the attempts by the appellants to roll up the amounts payable in both contracts and treat them as consideration for the transfer of the assets is quite wrong. Is there anything else in these agreements? Lords, that's really all I have to say in the third branch of my submission. Can I finally turn to look at the attempt by the appellants to rely upon a breach of clause 15.4? The
15.4 of the acquisition agreement.
And if I could refer my lords to the pleadings, which are in tab 25. Page 4, tab 25 of the volume 2 of the core volume, I think. Mm-hmm. Yes. At page 483. If my lords could perhaps keep a finger in that tab, if I may. And also look at page 604. 604
Of what?
of the same volume.
604.
So if it's possible to have something marking page 483, but also have page 604, what we have on page 604 is Article 16 of the summons.
Sorry, we find page 604 where?
It's in a separate document, a separate bundle for us, I think.
Oh, sorry,
It's in the back.
I didn't realise that.
Sorry, it depends how you do it. It's in. I've got a page 604, which seems to be part of a record with.
Yes. If I could just explain, page
Yes.
604 is part of the summons in the damages action
Yes.
at the instance of Tullis Russell, as adjusted to 11th December 2008. And that is what was before the division when it opined on the matter of retention.
I'm being rather slow. Which paragraph are you directing our attention?
16
16.
on page 604.
Yeah.
And we'll see that any averments to the effect that Inveresk breached their obligations in terms of clause 15.4 of the acquisition agreement had at that point been deleted.
And just say again what that point was.
That was 11th December 2008, which was when the issue of the additional consideration and retention was before the inner house of the Court of Session.
Well, the second time round.
Well, what happened?
Oh, this point didn't arise the first time round.
What happened was that we didn't have enough time to deal with entitlement to additional consideration and retention, so retention was dealt with in early 2009. Is that right? Yes. March 2009. So these are the pleadings that were in front of the extra division when the issue was debated, the issue of retention was debated before them.
This is, looking at page 583, this is as adjusted at 11th December
Yes,
2008.
indeed.
Well, why do we see what we do at page 483? That's in a thing which is October 2009.
Because
It's come back in again?
because Tullis Russell added back or made new averments. I think probably fair to say.
It's slightly different wording.
Made new averments about a breach of 15.4. And what they say is that two customers with such pre-acquisition claims, IT Papier and James McNaughton Group, sorry, I'm looking at page 483, were written to in a way which would reasonably be expected to damage the commercial interests to the pursuers. And then there's reference to some letters. Defenders did not obtain the pursuers' prior written consent to contact these customers in such term, thereby breaching their obligations in terms of clause 15.4 of the acquisition agreement. Now, my Lord, there are no averments to the effect that these alleged breaches of contract caused the pursuers in that action, Tullis Russell, losses which would entitle them to retain £900,000 or thereby of the additional consideration. And in this part of the case, as we've discussed on a number of occasions, the rationale of retention is to provide a form of security. Now, my learned friend yesterday made a number of assertions that these two letters were an effective cause of a global loss of 4.8 million. But in my submission, there are no relevant evidence that these breaches led to any losses which would entitle the pursuers, Tullis Russell, to retain.
Your answers on the next page, is that your answer on the next page?
Yes.
And is there a response to your answer? Your answer is that you've paid.
Well, that's in relation to
Or is that a different
the
one?
19 customer claims, which are mentioned at page
Oh, I see. That's a different one.
63 B2C. So I think that's a different.
So the furthest it's taken in the pleading is the sentence or the passage just below the C on page 483, saying they were written to in a way which could reasonably be expected to damage. But you say they don't say that it actually did result in any damage. Is the point as narrow as that?
Well, it's not just that, my Lord. It's the fact that there is no. If we look at, I'm just going to invite the court to go on and look in tab 25 at article 28, sorry, 27 and 28. Where they say the defenders.
Sorry, what page you on?
I beg your pardon, page 505, which is article 27 in the pleadings as they are now. The defender's failure to comply with the quality standards and terms of clause 5 of the services agreement, and 2, their failure to comply with the required standards of quality of products they manufactured in clause 2(1)(c) and E of the services agreement, and 3, their direct handling of customers' claims in the way condescended upon in articles 11, 12 and 16 of condescendence in breach of clauses 14.6 and 16.2d of the services agreement and clause 15.4 of the acquisition agreement. Now, bearing in mind at this point that in Article 16 we're relying on 2 letters, were breaches of contract that caused significant loss of sales to the pursuers, not only in relation to the Gemini branded products, but also in the pursuer's business generally, and as a consequent loss of profit on those sales. Those breaches of contract caused important customers to cease doing business with the pursuers, caused other customers to reduce their level of orders, or not transfer their business from the defenders to the pursuers at all, thereby causing loss to the pursuers as further condescended upon. And then Article 28 on page 86, as a result of the defender's breaches of contract, as averred in Article 27 of condescendence, the pursuers have suffered loss and damage that was in reasonable contemplation of the parties when they entered into the contracts, and that in any event naturally flows from these breaches. In the absence of the defender's wrongful acts, the pursuers reasonably estimate that they could have achieved additional sales in their business of 12,643 tonnes of products, earning an additional £4.8,689,000 by way of profit. That sum is calculated by multiplying the lost tonnage by a margin of £433 per tonne over the period from the beginning of the 4th quarter of 2005 to the end of the 3rd quarter of 2008, as that sum is discounted by the nominal cost of capital of 13% and so on and so forth. So what we have is really the assertion made by my learned friend yesterday that the matters complained of in Article 16, the letters to 2 customers, were an effective cause of damages of 4.8 million.
Yeah.
And in my submission, it simply isn't a relevant basis upon which to retain on the hypothesis that the additional consideration of £900,000 odd is due. That is not a relevant basis upon which to retain that amount of money.
This claim has gone to proof for answer, hasn't it?
Sorry, my lord?
Has it not gone to proof for answer?
This case?
This.
Yes.
So, I mean, what can we do about it? You can hardly come here and say that's not relevant when it's gone. You haven't. I mean, the question of its relevancy is before Lord Drummond Young.
It's not a question of. I'm not asking this court to adjudicate upon its relevancy
Well,
per se. I'm asking the court to decide whether these averments added since the extra division considered the matter constitute a relevant basis for retention.
Yeah.
And that's what we're debating. It's never.
You were saying they've at least got to show an arguable basis for a retention in the sum of 900,000 or alternatively
Indeed.
168,000 or whatever the amount is.
That's all. And this matter hasn't been.
So can we go behind the four? I mean, I'm just asking. What do you say? They've said, maybe implausibly, that they lost £4,800,000 as a result of this.
Well, they couldn't have done because, at any rate, for these 2 letters, because one was in January and the other was in February 2006.
Is it a point on specification, really? They haven't split it up into the right figures. I don't know quite what the point
It's
is.
neither a point of it's not particularly a point of specification. It's simply that in order to retain the money, as Lord Clark says, they have to set forth an arguable basis for retaining £900,000 on the basis of the alleged breach of 15.4.
And since they're 4.8 million, it covers a period from the 4th quarter of 2005 to the 3rd quarter of 2008. They haven't done any such thing.
Indeed.
Well, time is running on a bit. The Dean Faculty will have to have an opportunity to reply to you. Is there much more you need to say on this chapter?
No, my Lord, I'm subject to
I
just
do
checking.
notice, perhaps I got it wrong, that at pages 518 to 519 of Appendix Part 1, you appear to be claiming retention the other way round.
Yes, but as we discussed, that was on the assumption that this claim for retention is okay, then why shouldn't we retain it?
Yes, fair enough.
Yeah, that's a simple.
Well, the irony is that there may be a judgment in the other action before this action.
Who knows?
In which case you'd be better off. In which case you'd be better off arguing the opposite. I mean, presumably the same principles of retention apply to both claims.
Yes.
Yes, it would have to be.
Lords, unless I can assist your lordships further, those are my submissions.
Thank you very much, Mr. Curry. Mr. Lake, do you want to add anything?
My Lords, I have nothing to add.
Thank you. Dean of Faculty.
Lords, I'm obliged for the opportunity and will be brief if I may. Can I deal with the point that was last addressed by my learned friend, which is really a matter of pleading? And I don't want to go through the pleadings at length, but may I notice this, that even with regard to tab 26, which are the pleadings which were before the inner house, there is in fact a relevant case made out under clause 15(4), bearing in mind always, so far as any specification point is concerned, that this is a commercial cause action in which it's not just the pleadings, but the relevant requirement for summaries and witness summaries that has to be considered in determining the relevant specification of the averments, unlike in an ordinary action. Just as a matter of note, as one goes through tab 26, if one goes to page 596 at the foot, one begins with the reference to Inveresk actions being in breach of both clause 14.6 of the services agreement and clause 15.4 of the acquisition agreement. And the averment that the Inveresk approached the task of dealing with customer claims in a way that ignored the need to protect the goodwill. 596 to 597. At 598, towards the foot of the page, unfortunately it's not lettered, again there's a reference to breaches of clause 15.4 of the acquisition agreement because of the manner in which particular customers were addressed. And there, of course, the understanding of Inveresk was that their product had been seriously affected by staff sabotage during the manufacturing process. At 599, it's pointed out that again in breach of their obligations under 15.4 as well as 16.2 of the services agreement, Inveresk did not seek consent before contacting customers direct, and particular reference is made to Bemrose Booth and Papier Union. I should explain that the vast majority of sales in respect to this product were to be to a limited number of merchants in the continent of Europe. They, in turn, were interconnected to the extent that they tended to be part of one of three groups of companies that operated in Europe. So where there was conduct directed to one merchant, it potentially had a knock-on effect in other countries in Europe because that merchant was part of a group that operated in other parts of Europe. Just sticking with the pleadings, at page 600, one has again a reference to 15.4 being breached as well as 16.2, and then at 602,
I don't see, no, it's the very bottom of the page.
it's the very bottom, I
yes.
apologise, my Lord, at page 600.
Yeah.
With regard to confrontational and inflammatory language. At 602, halfway down, there's a reference to the tables. And what happened was that the tables are incorporated into the commercial action, and they are fairly detailed tables showing the impact on individual customers by reference to manufacturing defect and the consequent loss of sales. At 604, the reference to both clause 16.2 of the services agreement and clause 15.4 of the acquisition agreement was deleted, and reference was made to the customer complaint settled by Tullis Russell and the table in particular. That merely dealt with the matter of indemnity for faulty products, not with the damage to the goodwill. At 606, again, having referred to clause 14.6 of the services agreement, there's also a reference to the obligation under 15.4 and the duty to notify Tullis Russell of claims that came to their attention and the breach of that obligation.
So there isn't any attempt to divide them up in terms of causation or loss? Because I understand this point only arises because it might be thought that you might succeed in relation to the asset agreements.
And not the services
fail
agreement.
in relation to the service agreement. It's not being suggested there's any problem if you succeed in relation to both. I think if I've understood it correctly. And so what's being said is, well, you've got to, on that hypothesis at least, you'd have to identify an arguable case of specific loss in relation to the asset agreement. And you haven't made any attempt to do that, and so you obviously can't have a retention in relation to it.
Well, my submission is that if the breaches of the asset agreement at clause 15.4 are an effective cause of the loss,
The whole of the loss.
the whole of the loss,
Well,
it doesn't require...
where do we see that averted? I mean, you haven't made any attempt really to avert
At 613, my Lord. Halfway down the page, each breach made a contribution to the accumulation of the loss complained of. Insofar as any other conduct condescended upon by Inveresk may have contributed to Tullis's loss of profit, it did not make a substantial contribution to the loss of profit claimed. And to say that each breach made a contribution to the accumulation of the loss complained of, because it is a global loss, because it couldn't be broken down in the circumstances, is sufficient in my submission to warrant a case that each was an effective cause of the loss complained of.
In fact, forgive me, I'm lost. Why are we looking at it in this version of the record?
Because my learned friend did. Because he was concerned to look at the pleadings as they were before the inner house. But of course, it's moved on.
So we don't,
Yes.
yes, well,
And in fact, tab 25 represents the current state of the
Yes,
pleadings.
Do we have a
Sure,
similar
you'll find the
averment
same.
in tab 25?
Yes, my lord, and I don't propose to go through them ad lonum unless your lordships wish me to do so, but I'll simply give the references
Yeah.
to the record dealing with clause 15.4. They're at 454E,
454.
E,
Yes.
460C, the 461C, 471E, 483D, 489A, and 505 C to D,
Yes.
where in particular it is averred by reference to the earlier articles of condescendence
Yeah.
that Inveresk conduct in breach of clauses 14.6 and 16.2 of the services agreement and clause 15.4 of the acquisition agreement were breaches of contract that caused significant loss of sales to pursuers, not only in relation to the Gemini branded products, but also in the pursuer's business generally, and the consequent loss of profit.
And there's a top of... Sorry, I'm going.
These breaches of contract
Yeah.
caused important customers to cease doing business with the pursuers, caused other customers to reduce their level of orders, or not to transfer their business from the defenders to the pursuers at all.
And then the top of page 86, we get the contribution point, which we saw in the earlier version.
Indeed, sir. And the point that was being argued, my lord, was this, that the impact upon the goodwill, in fact, extended not only to the product itself, but to a wider impact upon the standing of Tullis Russell in the market. And that, again, is why there's a global claim, and that is now being offered for proof at the present time. But coming back to the short point my Lord Clerk mentions, I submit that there is sufficient in the averments that if at the end of the day the only breach established was clause 15.4 of the acquisition agreement, it would still be a relevant basis of claim. And therefore there is a right to retention even if one does not extend beyond that particular condition. My Lords, could I turn to a second point which I would seek to deal with again shortly? The learned friend mentioned the case of Cladder steamship at tab 12, and he mentioned it but didn't actually go to it. He was right to notice when he mentioned it that it's perhaps the only instance that we have of two contractual documents implementing what was referred to as one overarching agreement. Now, of course, the facts and circumstances of each case may differ. I acknowledge that. But if your lordships have the Bundle of Authorities, Volume 1 at tab 12, shortly put, there was a verbal agreement whereby one party wanted to acquire two steam vessels from another party. In the event, two separate contracts of sale were drawn up, one for each vessel. One vessel was not available for delivery, and the purchaser refused to accept delivery of only one vessel and not both. The seller asserted that as they were contained in two standalone contracts, each had to be construed separately, and the right to repudiate performance, because it wasn't complete performance, could not be maintained. It was held that the object of the two contracts was to give effect to and not to supersede the agreement for the sale of the two ships together, and the purchasers were entitled to refuse to accept delivery of and pay for one ship without the other. And one is dealing essentially with issues of mutuality of obligations, albeit not strictly in the context of retention as such. The Viscount Finlay, at the foot of page 134, notices, this is the last three lines at 134, the Cladder Company contended that the two contracts were separate and distinct and not in any way depending upon one another, and that Messrs. Stephen were bound to take the factor at the price of £60,000 by herself. The Cladder Company contended that as there was nothing in the written agreements themselves to make them interdependent, the surrounding circumstances could not be looked at for this purpose. Now, I just paused to notice there, my learned friend conceded that there may be a presumption, but it's a very curious presumption, according to him, because it can only be displaced by an express written agreement. And I would notice that it's not very much of a presumption if that's the only way it can be rebutted. But just moving on, Viscount Finlay noted, Lord Hunter, however, said, I do not think that the rule of law which excludes parole evidence to qualify a written contract precludes a party from showing that two separate documents drawn up and signed at the same time are in effect two parts of the same contract, or to put this in a different way, that there is such an interdependence of the two contracts that fulfillment of the one cannot be insisted on, but the party seeking to enforce the one contract is, it may be by no fault of his own, unable to make implement of the other.
So he's sitting in the outer house making that pronouncement. Have you studied the basis for what he was saying?
The session papers, my lord, are not particularly illuminating except to this extent. It was apparently being argued that there was one oral agreement followed by two written contracts.
Yeah, I see.
The inner house differed, but it's quite clear that, as Lord Mackenzie is quoted as saying, they thought there is not enough in the circumstances known to both parties to make the two transactions interdependent. Now, it is quite clear that their lordships agreed with Lord Hunter on this matter, that it was clear looking to the circumstances that there was interdependence, such that fulfilment of one could not be insisted on where the other party was not prepared to fulfill the other. And at the foot of page 135, he noted, if the result of the evidence is that the two ships were to be sold together for £100,000, and that the two documents were executed merely as pieces of machinery for carrying out such a sale, and not to replace it by a new arrangement, which would vitally alter the rights of the two parties, the contention of Cladder must fail. I acknowledge there, my lords, that emphasis is being placed on the earlier oral agreement. But as Viscount Finlay goes on to note at the foot of page 136, the question is really a question of fact. The evidence on behalf of Messrs. Stephen and the absence of any contradiction on the part of Cladder are, in my opinion, decisive to show that the two contracts were executed and delivered only for the purpose of carrying out the arrangement for the sale of the two ships together, and that they are therefore interdependent. Now, it's not necessary that they be one contract. It is necessary that they be interdependent. And in my submission, one can look at the facts of this case and conclude from the terms of the two agreements themselves that they are clearly intended to be interdependent. And their other lordships expressed the matter in similar ways.
I mean, it may sometimes depend on the circumstances. I mean, you could imagine that, you could have thought that somebody you could construe these things as two separate contracts each for a sale of a ship, because that was a quite commercially possible thing. Here it's much more difficult to see that you could have had two completely separate contracts, one for services and one for acquisition. It seems to me it'd be very odd. I mean, nobody would want the one without the other, so to speak, whereas you might want one ship.
You might want one ship, my lord, but the acquisition agreement and the services agreement cannot stand independently and on their own. And indeed, it is a matter of note that the joint statement of facts and issues acknowledges that the purpose of the transaction was the acquisition of the assets and the maintenance of the value of those assets.
Well, I mean, another way of putting it is page 137, about halfway down, where I think it's Viscount Cave is saying that when you look at one contract, you can't actually accept it as containing the whole agreement between the parties. And you would say that here too, would you, that if you look at the service agreement, it can't really be understood without the agreement for the sale of the asset and vice versa?
Absolutely. And if one looks in particular at recital C of the services agreement and at clause 22, one could say that that comes as close as one could ever expect to saying that these contract documents are interdependent.
Of course, this was a quite special kind of case, wasn't it, where the question was whether or not there was an oral agreement which showed that the written agreements didn't contain the whole of the agreement between them. And
Lord, of course,
I'm not quite sure what it has to do with the doctrine of retention.
it may, of course, be distinguished, but it is noteworthy in my submission that their lordships were concerned by the interdependency.
But obviously you could have a contract which contains three documents, namely two written contracts and an oral contract, when construed together shows that it's really one contract.
We have here a transaction expressed in two contractual documents in my submission. I merely notice that Cladder is the closest that the court has come in the context of a Scottish case to consider the impact of two contractual documents which may be construed as one, and their interdependence is relevant because, of course, a party was not entitled to insist on partial performance, and that essentially brings us back to such doctrines as mutuality of obligation, which underpins the notion of retention.
Lord Dunedin at page 138 was a little more cautious about this, wasn't
Indeed.
he?
And Lord Shaw laid emphasis, as my Lord Clerk does, on the notion, looking at Lord Shaw at, I think, page 140, once the overhead contract is established and not abandoned, each contract separately stated deals with the item with which it is alone concerned and forms a part of that general bargain which, in my humble judgment, must here be affirmed as having been unquestionably made and never abandoned. So I accept that there are facts here that can be distinguished in Cladder from the present circumstances. Nevertheless, when addressing this issue, the House was concerned with the interdependence that was apparent between the two contractual documents. That's the only point I take from Cladder. My Lords, unless there's anything further on the issue of retention, I would turn back for a moment just to the first issue of the additional consideration. In opening, my learned friend noted that the obligation of Tullis Russell was to procure the audit. I just notice that Inveresk case is not that we are in breach of that obligation, nor is their case that they seek specific implement of that obligation. And the reason for that may be in dispute, but it is noticeable if one goes to, again, the appendix part 2 at tab 8. We have Tullis Russell's letter of 20th February to Inveresk's lawyers. And what is interesting is that this was referring to a request that there be an extension to the time period for completion of the tonnage audit. And in the third paragraph, it states, you suggest that the audit was not conducted on 5th February with the inference that the audit cannot be completed. We understand that PwC attended at Tullis Russell's premises on 5th February to undertake preliminary work on the audit. Having regard to the timescale for the audit process, this was entirely sensible. We understand that during the visit, PwC were provided with full access to documentation and provided with all information requested. As you are aware, the audit process is ongoing. It is in this context that Inveresk was provided with the opportunity to make submissions, which will be considered by PwC. We also understand that notwithstanding Inveresk's failure to engage meaningfully, PwC attended at Tullis Russell's premises this morning to undertake further work. We believe the audit can be completed in a short time frame. However, that will be dependent upon Inveresk engaging sensibly. Having regard to Inveresk's obvious interest in concluding the audit, we see no reason for Inveresk to refuse to engage sensibly. And then you assert that Tullis Russell delayed in providing Inveresk with a copy of PwC's draft terms of engagement, and then there's a reference to when those were intimated. I just notice on that last point, although the draft terms of engagement were just that, the audit process was apparently proceeding at this stage. And if, in fact, Inveresk had alleged that Tullis Russell were in breach of their obligations by failing to procure within 14 days, one anticipates, albeit it may be disputed, that they would have been met by a submission founded upon prevention, because as a matter of principle, a party cannot be in breach of a contractual obligation if they're prevented from tempering it by reason of the other party's actings. But as I say, that's entirely academic, because Inveresk have no case of breach of contract, they have no case of specific implement. So where do we stand as regards the audit? Well, it respectfully appears to me that if Tullis Russell have failed to procure the audit within the specified period because of their own breach of contract, then Inveresk can sue them in damages for breach of contract, and the measure of the damages will be the sum that would have been payable otherwise as a consequence of the tonnage audit. If Tullis Russell are not in breach, and for some reason the machinery has entirely broken down, that cannot disable Inveresk from recovering additional consideration, because the primary obligation that Tullis Russell owe to Inveresk is to pay the consideration for the assets, including the additional consideration. And if the machinery to calculate the tonnage has broken down, then a la Sudbrook Trading Estates and their lordship's conclusion in that case, the machinery is subsidiary to the principal obligation. And if the court has to ascertain the tonnage, well, it's a straightforward job for them to do so, and they will do so. But I would never suggest that because the machinery in Part 3 is broken down, even by reason of Inveresk's actings, that they're disabled from insisting upon Tullis Russell's primary obligation, which is, of course, in terms of Clause 2, to pay the additional consideration.
Yes. Well, I mean, this gets back to the procedural point I was raising earlier. I mean, would you object to us sending the case back to the Inner House to proceed as a cause rather than proceeding to dismiss ourselves?
No, my Lord, because it would give Inveresk an opportunity, or Tullis Russell, depending upon your Lordship's decision, to determine where they take the matter now. Yes. What I simply seek to emphasise is that there's nothing in the point that Tullis Russell must procure the audit and didn't do so within 14 days. We know where we are at the present time, but we can leave to Inveresk, in light of your Lordship's decision, or Tullis Russell, an opportunity to consider how they proceed. If the failure to secure the audit is due to Tullis's breach of contract, they may have a claim for damages, and we know what the measure will be. If the machinery is broken down, that does not disable them from pursuing the additional consideration, and they can then address that issue as well. So
what was the name of the case you mentioned?
Sudbrook Trading Estate, my Lord. It's not in the bundle. It was the case where the Sudbrook Trading Estate and Eggleton, it's 1983 appeal cases, page 444. And very shortly, it was a case where there had been an agreement between the lessor and the lessee that at the end of the lease of the premises, each would appoint an expert to fix the value of the demised premises, and the lessee could then purchase them. And the lessor just refused to appoint an expert to do that, and said, consequently, the machinery is broken down and you can't acquire the premises. And the court said, well, that can't be right. On a true construction of the agreement, the machinery was a subsidiary part of the contract, and the court was capable of substituting its own machinery to ascertain the fair and reasonable price, which was what was to be paid.
So that would leave the court deciding all the things which the expert was going to decide, would it?
it would lead the court...
Another way of looking at it would be to say, well, maybe the 14 business days have gone by, but the clause is still there, and that there should now be an expert appointed,
Indeed, so.
or the court should appoint an expert.
Indeed, and that would arise if, in fact, for example, Inveresk were held to have prevented the implementation of the audit within 14 days. The time would then be prorogated in order that the audit could be completed.
Would all these be a matter for the future, would they? Because we can't determine any of those matters.
In my submission, no.
It still remains unclear to me whose obligation, how any issue about the product, whether that falls within the expert's obligation or is a matter for the court or is a matter for mediation or what.
That's an interesting point, my Lord, because if we actually look...
Maybe a bit late in the day to discuss it.
And what's happening about the second conclusion? That's still under
It is worth noticing what actually the position is at this stage, because if we look in the pleadings for Inveresk, in the action, where the pleadings are at tab 8,
yeah.
and I don't necessarily accept their characterisation of what the issue is, but if you turn to their own pleadings in the core bundle, tab 8 at page 179, at 179B to C, their case there is explained and averred that any issue as to which of the lines produced and sold by the defenders fall within the definition of product in the asset purchase agreement is not one that in terms of the agreement is subject to determination by the purchaser's accountants.
Yeah.
So that's the position.
That's their case, is it?
Well, that was their case.
Or is that your case? What's your case?
Oh, no, well, I'm perfectly content, my Lord, that we should determine that through the expert. If one turns on to 180...
Whose case is 180?
This is my case, my Lord, at the foot of 180, letter E. The determination of what the proper definition of the product is for the purposes of deciding the tonnage, is a matter properly reserved to the expert and not the court.
Yes.
So what's being mediated?
Well, if you go to tab 2, the inner house decision at page 5, it says there, in the introduction of the opinion of the court, they also, in terms of the second conclusion of the summons sought a declarator, that's Inveresk, but before this court, parties were in agreement that that matter should be made the subject of determination by an alternative dispute mechanism entered into between the parties.
What matter? What matter is that?
I understand from a learned junior that that refers to the machinery in part 3 of the schedule for expert determination. Because that's the only matter covered by the declarator, and I can't see what else there is. I'm certainly not aware of any further...
Where is the declarator?
That's page 162.
That's the second conclusion, my Lord.
Page 162.
Page 162.
So an answer to that would tell you what the experts are to look at in carrying out the exercise under Clause 5. Is that right?
Right. But what's recorded at the foot of page 5 is rather curious, it appears to me, but at the end of the day, if the matter is remitted back, then the commercial court can determine the issue of whether it is the expert.
But the declarator sought a determination by the court of that, is that right?
It has.
And what is said on paragraph 1
is
that there's an agreement that, quote, the matter be made subject to determination by an alternative dispute mechanism, which is an odd way of putting it, if they meant the expert, because...
Oh, no, I don't think they do they? I mean, I've assumed it's something different from the experts.
Yes, I thought so too. But at any rate, if the parties have agreed, and presumably there's evidence of agreement.
I mean, the only person who seems to know about this agreement is Lord Clark. Nobody else seems to.
Well, my Lord, I apologise if I can't elaborate upon the position, but what I would say is this, that within their pleadings, the parties are at issue as to whether the court should determine the definition of product or whether the expert should determine the definition of product.
Yes, I see that on the pleading, but it looks as though it's gone off, the issue has gone off for determination elsewhere. And if you get a result which is in your favour as a result of that, does it all in the end just come down to arithmetic as to what the pursuers are entitled to? Because you know
largely it would be, my Lord. But I'm not aware of it going off to any form of third party.
So are you asserting that the Inner House are wrong when there was agreement? There was no such agreement. Is that your case or not?
My understanding is that they're just recording that, in fact, the issue is to be determined by the expert under Part 3 of the schedule. But if the learned friends have a different understanding of the position, I'm open to correction on that.
I see. Right.
But it is rather
I
curious.
suppose it'd be too optimistic to hope that somebody might be able to send us a letter agreeing whether or not it has been agreed to resolve this matter by some other process, and if so, which process?
And moreover, precisely what issue?
Yes.
It would be very helpful to know, because I can't really believe Lord Clark was just reciting there what he thought Clause 5 meant, that it was before, that because the pleadings show there's a dispute as to whether it should go before them.
The pleadings show that there is a dispute about the issue.
Yes.
Lord, I pause because the prospect of parties agreeing any form of communication
I said it was too optimistic.
is, I suspect, if not remote, at least challenging.
Yes.
That each party could tell us precisely what their case is on the question. Namely, 1, was there agreement? 2, who were the parties to it? 3, what were the terms of it?
Well, my position is that there is no additional agreement.
And that the Inner House had it completely wrong.
The expression of the matter seems to be not as we would understand it. I would ask my Lord to allow me just a moment to take instructions to be more specific about this.
I didn't tell us the other side, but their positions as well.
I'm advised that, according to my agents, that they proceeded on the understanding that it was conceded by Inveresk that it was a matter for the expert, and that is what is recorded here. But
What, in writing or orally or what?
no, my Lord, I believe that was the position before the court.
Yeah. I don't know whether you were able to help us.
Sounds unlikely.
Predated my time, so
Yes, Mr.
don't
Lake.
know.
Perhaps your learned junior could help.
Well, I've asked him, and as I understand it, it was indicated by this side before Lord Glennie that that would be a matter for the expert.
I see.
I'm not at all clear
Yes.
what this has got to do with the
No, well,
issue
it
before
maybe
the
it's not
court.
crucial, but it's just interesting to know
Yes.
what
But
Lord
it has to be
Clark
common
was
ground then that it's a matter for the expert.
Well,
Yes, I understand
it
that
is.
to be the position.
Yeah.
So can we say it's common ground that it's a matter for the expert? And that's the question being what the products were, as it were.
Yeah, that
My
seems to
Lord, if there is common ground, however small it may be, I am perfectly willing to stand upon it. And it does appear that if the matter was considered before Lord Glennie, then the parties are agreed that the determination of what is product for the purposes of Part 3 of the schedule is a matter for the expert at the end of the day.
So the concession is what? That what is product? Because there are various questions involved in this. Namely, what is product as a matter of law within the meaning? And secondly, what were the facts? I mean, those are two different questions. And so is it common ground that all those questions are matter for the expert?
It is, my Lord. It respectfully appears to me that it's an issue of mixed facts and law as to what is product as defined for the purposes of Part 3 of the schedule.
Lords, I find myself in a very difficult position here, but it's just been intimated to me that my clients wish to withdraw any concession that was made to that effect.
Yes, well,
long time ago.
it doesn't fit with your pleadings, I must say. I mean, your pleadings indicate there's a dispute about the
Yes,
point.
the reason I haven't ever gone into this in any detail is I have to say it escapes me what relevance this issue has to the decision before this court. And it seems to me that this is a matter that's much better expurgated before the commercial judge.
Yes.
Before
So your request for the declarator remains alive?
Yes.
Yes.
Yeah, the relevance really, if any at all, goes to the question as to whether if you fail, the action should be dismissed or go back to the commercial judge.
And I have to confess that in the first place, I haven't really applied my mind in any serious way to where we go next if we lose. And B, it does seem to me that that decision will be influenced probably, or at least possibly, if your lordships are against me on the first argument, on the reasons for that decision.
Yes.
So,
My Lords, having heard that, I'm perfectly content to accede to the suggestion that the matter should be remitted back.
Yes.
The only last observation I would make is that when looking at clause 5.4 and indeed 4.4a, my learned friend imbues the word shall, where it appears there with a clear and distinct meaning, must. And one doesn't really see why it shouldn't be invested with the same meaning where it appears in 4.4b. If within 5 business days adjustments are not agreed, clause 5.1 shall apply.
Yeah.
My Lords, unless there's any further matter upon which I might assist, I would rest my submissions there. And I'm obliged for the opportunity for a response.
Well, thank you very much. The Court is extremely grateful to all counsel for their submissions, both in writing and orally these past few days. We will take time to consider our decision.